A deed, a will, a power of attorney.
Three pieces of paper that decide who gets the house, who makes the call, and who signs when you can't.
Most people never learn how any of it works.
Until the day they need it, usually the worst possible day.
I'm Grace Sias, a commissioned Florida notary.
And I'm Mark Sias, retired nurse and recovering paramedic.
Together, we run Noble Notary and Legal Document Preparers.
And we prepared thousands of these documents for families who didn't have $3,000 to spend finding out what they needed.
So every week, we take one document, one situation, and we break it all the way down.
What it does, what it costs, what gets it rejected at the clerk's window.
And when you actually do need an attorney, we'll tell you.
This is the Legal Document Playbook. Legal documents.
Without the attorney price tag.
The deed was signed, notarized, and filed. The daughter was named. Everyone thought the house was handled until the county rejected it.
And that is the trap. A document can be real, properly signed, and still be the wrong document for the result you want. Before you pay, sign, or file anything, ask 5 questions.
What do you want to happen? Who is involved? What property, money, or authority is involved? Where does this need to work? And when does it need to happen? Today, we are covering a practical checkup for answering those questions before the paperwork takes over.
We are Mark and Grace Sias of Noble Notary and Legal Document Preparers. We are not attorneys. This episode is general education, not legal advice, and requirements can change by state, county, court, recorder, and individual situation.
The first question sounds obvious, but it is the one people skip. What outcome do you want? Not which form did the internet recommend. What do you need the document to make possible?
Exactly. I need to take care of everything for mom is loving, but it is not specific enough. Does the daughter need to help with bank accounts, discuss medical care, sign a real estate contract, handle benefits? Those may involve different documents, different institutions, and different rules.
A will generally gives instructions for after death. It does not automatically let your daughter manage your bank account tomorrow. A power of attorney may address authority during life, depending on its terms and the law that applies. An advance directive or healthcare designation may address medical decisions.
And a trust is not simply a fancier will. It may involve management and distribution of assets, but whether it fits depends on the facts and the goal. Similar family concerns can point in very different directions.
Write the goal as one sentence. I want my sister to help with finances if I cannot. Or, I want instructions for distributing property after I die. Or, I want to transfer an interest in this house. That sentence keeps the document from becoming the boss of the conversation.
Then ask who is involved. Who is making the plan? Who may receive authority or property? Who owns the asset now? Are there other owners, beneficiaries, agents, spouses, children, or successor agents? Use full legal names and check prior names when they matter.
Right. Everybody knows who I mean works at the kitchen table. It does not always work for a bank, court, or recording office. If one record says Robert Smith and another says Robert J. Smith, do not guess whether that difference matters. Verify it.
And ask what is involved. Which account, which property, which business interest, which debt or benefit. My assets starts the conversation, but it may not provide enough information to prepare or review anything responsibly.
For a house, find the most recent deed. Look at the owners, the legal description, and any reference to a trust, estate, life estate, or other interest. Also note mortgages, home equity lines, divorce orders, probate matters, or anything else that could affect the property. A homeowner may say, I want to add my daughter so she can get the house later, and the natural next step seems to be
to ask what later means. Later after death? Later after a sale? Does the homeowner want to share control now or keep control completely?
Exactly. I used to hear add my daughter and think, all right, let us look at a deed.
And I would say, hold on. The daughter might be the intended future recipient, but that does not answer whether a current transfer is wanted, whether other family members are affected, or whether tax, creditor, mortgage, or probate questions need legal analysis.
But if the family has already decided who should receive the house, why not start with the deed and save time?
Because deciding who may receive it someday is not the same as deciding to change ownership today. If the old deed lists Daniel and his late spouse, for example, the ownership chain may need attention before anyone adds a child. The document can be beautifully typed and properly notarized and still miss the actual problem.
That is a fair correction. The goal leads, the facts follow, and the document comes after both. I would rather spend 10 minutes clarifying the outcome than spend 3 Saturdays repairing a rushed filing.
Good. Now ask where. Where does the document need to be signed, used, accepted, or recorded? The signer may live in Florida, own land in another state, and use a bank with its own review process. A deed usually connects to the county where the property is located.
Notarization and recording are separate steps, too. A notary verifies a notarial act. The notary does not decide whether the document accomplishes your legal goal. Recording offices may have fees, cover sheets, formatting rules, indexing requirements, or rejection reasons that vary by location.
Then ask when. Is there a closing next week? A court deadline? A planned move? A new diagnosis? A parent who is struggling with decisions? A separation that is peaceful today but uncertain tomorrow?
Urgency tells you how quickly to organize, not whether you should skip the questions. What is urgent and what is merely uncomfortable? Those are not always the same thing.
If someone may no longer understand what they are signing, stop treating it like routine paperwork. If there is pressure, family conflict, or a major financial consequence, an attorney may be the right next call. Mama Bear says, protect the person first, then solve the paperwork.
Before that call, gather what you can. Identification information, current deeds, existing wills or powers of attorney, property and account details, marriage or divorce information when relevant, and the names of everyone involved.
Also, bring the details you are tempted to hide because they feel messy. Is there a mortgage, someone deceased, a blended family, a business, an active lawsuit, a document already rejected? Those facts are not embarrassing. They determine what kind of help is appropriate.
Let us test the questions with a fictional caregiver. Elena wants to help her mother pay bills and speak with the bank. The outcome is authority during Mom's lifetime. The people are the principal, the proposed agent, and perhaps a successor agent.
The property or authority includes specific bank accounts, insurance, benefits, or real estate. The place includes the bank and the state whose rules apply. The pressure is time and Mom's current ability to understand the document. Notice what we did not say. Download a form and sign it.
And if Elena says her brother thinks she is pressuring Mom, or Mom seems confused, the path changes immediately.
Exactly. Conflict, capacity concerns, unclear ownership, complex business or tax issues, creditors, lawsuits, and court proceedings are warning signs. That does not mean the family is stuck. It means the situation deserves the right professional before anyone signs.
Here is the worksheet. Write 5 words. Purpose, people, property, place, pressure. Under each one, write what you know and what you still need to verify.
Then add one final question. What could make this complicated? That single line can keep a straightforward preparation from being mistaken for a legal strategy decision.
Purpose, people, property, place, pressure. Start there before you search for a form, and you are far less likely to use a will for a living authority problem, sign a deed without checking ownership, or discover the filing rules after the deadline.
Visit the Noble Notary and Legal Document Preparer's website for educational information and document preparation resources. Bring your 5 answers with you. If the facts are simple, organization can make the process smoother. If they are complicated, organization helps an attorney understand the situation faster.
And remember, Noble Notary and Legal Document Preparers is a non-lawyer document preparation service. We are not attorneys and cannot provide legal advice or choose a legal strategy for your situation. Laws, forms, notarization, recording rules, and deadlines vary.
When there is conflict, uncertainty about capacity, complicated property, significant consequences, or a court matter, consult a qualified attorney. Getting that help is not giving up on cost-conscious planning. Sometimes it is the most cost-conscious decision you can make.
A better document conversation starts before the document. Thanks for spending this time with us.
That's a wrap for this episode. Until next time, take care of your people, keep your important papers organized, and ask one more question before you sign.
That's the playbook for this one.
If this episode saved you a phone call to a law office, do us one favor. Send it to the person in your family who's been putting this off.
Everybody's got one.
And if you're ready to actually get your document prepared, that's what we do every day.
Deeds, wills, powers of attorney, advance directive, divorce packets, prepared correctly, formatted for your county, and ready to sign.
Go to legaldocprepnotary.com. Tell us what you need. We'll tell you straight whether we can help or whether this one really does need an attorney.
That's legaldocprepnotary.com or call us at 321-283-6452.
New episode every week.
We're Mark
and Grace Sias.
Thanks for listening.